Hi,
Hi,
Leanne.
how's your day going?
Great. I also was in court today. That's why I'm dressed so fancy. I normally don't dress so fancy, but today I did. I even put on a tie today, which and so you might ask, well, don't you wear a tie every time you go to court? And the short answer is no, because at this point in my career, many of the judges that I appear before are either my contemporaries or they're younger than I am. So I've actually gone tieless for most of my court hearings. But today, two things. One, I decided, hey, what the heck? I haven't worn a tie in a year. Why not wear one today? And I looked at the ties and I thought this one matched. So I figured I'll put it on. And the other reason was today I appeared before two brand new judges who were just appointed on two different cases. And I figured, you know what? Why not make a good first impression? They don't know who I am. So I put on a tie.
Well, there you go. And I'm in a jacket and a dress, but if I stand up, I don't know if people will be able to see, but I do have my leggings
Oh,
on
nice.
underneath, and I have my slippers, but I don't think I can quite get them into
Oh
the
my
camera.
God. Oh yeah, I saw those. Yeah.
Yeah, so I wasn't expecting to be in court literally the whole day. So I thought at some point I'd kind of change into one or the other, but it never happened.
Yeah. No, listen, I think there's a field of fashion design that will likely spawn from Zoom and COVID that is called from the chest line up clothing.
Yes.
Because what goes on below the chest line, really, why spend the money?
No, exactly. And you might as well be comfortable. I thought rather than like tights and proper shoes, I mean, my slippers are comfortable, my leggings are comfortable. So as long as you don't have to stand up in front of the
It's like
judge.
those Groucho Marx glasses that had a nose and a mustache. You don't need the whole mask. You just need what people can see.
Exactly. Exactly.
So what are we talking about today?
Today we're talking about something that comes up a lot, which is does a client need to provide financial disclosure? And I get
Two
asked that.
dirtiest words in family law.
Exactly. And nobody enjoys doing it. Nobody wants to do it. And I find often clients will do just about anything they can to try and get out of doing it.
Yeah, yeah. And I'll tell you, let's educate our viewers just on, first of all, what do those words even mean? That's number one. Two, why is this even relevant? Why do we care? And so I think let's start with financial disclosure. When a couple is together, it's not uncommon for one of them to be in charge of the finances in the home. Sometimes it's the man, sometimes it's the woman, but generally it's a division of responsibility. Somebody takes care of the bills, somebody pays the mortgage, somebody sets up PAP, pre-authorized payments for all of their expenses. And anytime there's like a major event, like buying a house or a car, they might participate together. But things that are more passive, like RSP contributions, TFSA contributions, oftentimes that's sort of one person's taking care of that. And of course, the more the traditional the marriage, the more likely that is being done by the husband. So historically, husbands took care of all of the finances and the wives took care of the home and the children. Obviously, things have changed in the last 30 years, but there is still a lot left over of that. And so when they split up, and I'm going to ask you this question in a sec, when you look at your clients of the last 10 years, how many of them have what I call financial literacy? How many of them even know what they own? How many of them even know what they owe? How many of them know what it costs to live? How many of them even know what the balance of their mortgage is? What's your answer to all of that?
Not very many. It's definitely, less than half for sure.
And pardon me for sounding gender-ish on this. I made that word up, by the way. But in my experience, the when I represent the wives coming out of a traditional marriage, who were primarily the homemakers. They may have been working. They might actually have a medical degree or a law degree, but the family made the decision for them to remain at home with the kids. In those marriages, even though my client, who is the woman, is brilliant, is smart, is knowledgeable, and is lovely, so many of them don't know what they owe, and how to run the household expenses.
Yeah.
And so fast forward to divorce, what is this thing called financial disclosure? Answer: this is the opportunity to level the playing field and ensure that both sides are fully in the know before they start dividing up the chips that were collected and accumulated during the marriage. And when someone says to me, I don't want to make financial disclosure, I immediately say to them the following 3 points. Number one, you have to. Number two, you need to ask the other side for it because you don't know everything that they know. And number three is, if you want me as the lawyer to give you advice on what you are entitled to or what you owe, well, if you don't make financial disclosure, it's like asking a doctor to give you an opinion on whether you should have surgery before getting the blood tests and the x-rays. You might as well not go see a doctor, because you're not going to be getting responsible, ethical, wholesome advice. And like by comparison, the role of a lawyer in a divorce situation is to not only negotiate, but to advise. How can you advise on what they should give or take without knowing all of the facts? So my question to you, Leanne, is, when you think about all those cases where someone has said to you, I don't need to know any of that, what do you say to them?
Well, I say something along the lines of what you just said. I tell them that we have to have that information, that in order for me to properly advise them as their lawyer and to meet my professional responsibilities, I need to have that information. I tell them that they can still agree to whatever they, if they already have an idea of what they want to agree to, they can still ultimately agree to that. But we need to have the financial disclosure so that they have a full understanding of what they, are entitled to. And if should they choose to waive some of their entitled, you can't waive what you don't know about. So you have to have it. I will tell them that, if they want their agreement to stand the test of time and to withstand any future challenges, that they need to provide the financial disclosure as well, because that could be a problem down the road. If disclosure isn't provided, it can be an out to get out of a separation agreement. And so it's extremely important. And I do get a lot of resistance from people on it, but I insist that they provide it. I generally don't take on clients who don't want to provide it, even though there is a provision where they can waive it. There is a waiver that they can sign, but I'm very reluctant to even take on clients, who are willing to sign that in those situations.
And what do you do when the client says to you, come on, Leanne, we have a house and we have an RSP, and I know what the value is of both. The house we're selling, it's going to get $1 million. The RSP, here's the bank statement, it's $50,000. Why do I got to fill out this 13-page form, which is a pain in my side? And by the way, my spouse feels the exact same way. We both agree that filling out that form is only going to cause us to incur legal fees, and we don't want to do it. So don't make me do it. What do you say to that person?
Well, I say to them that if they want me to represent them in the matter, that they are required to do that. I consider it to be my professional responsibility to ensure that there's proper financial disclosure. And if I'm going to be their solicitor of record, or if I'm going to be giving independent legal advice, or however it may come to me, and I don't really do a lot of ILA. But I insist on having that disclosure. There are lawyers out there who I think will proceed without it, and they're welcome to find someone who is willing to do that, but it isn't me.
So I give the same answer, but let me just pause for a second. For those of you that are watching right now, last few IG lives that Leanne and I did, we got some really good questions. So should you have questions on the topic of financial disclosure, certainly put that in the chat box. We'd be happy to answer them. But going back to what Leanne just said about the clients that say, not only one, what if both say, I don't want to do this thing. This is a pain. I don't know what I spend every month on X, Y, and Z. And yeah, I have some bank accounts. And yeah, I owned something when we got married. I had a car and a bank account and had some student loans. I don't want to have to chase down all those numbers. So let's skip the whole thing. So I say the same thing as Leanne, but I've got a little bit better at it. That's just the nature of the game, because it's not uncommon for clients to think, why is my lawyer making me do all of this homework? I just want my divorce over. I don't want to have to do all this homework. It's, you know, I'm not in school anymore. I don't do homework anymore. Just get me out of this divorce. Get me out of this marriage. I just want to move on and do me a separation agreement and let's get it done. So what do I say? I say that if you can, by the way, you can borrow this line in the future, Leanne.
Okay, should I be taking notes?
You could. It's all recorded. Is it recorded?
Yeah, that's true.
So you could say, look, I do a lot of divorces. I'm going to do yours. And
I couldn't hear you there. Your voice went out. I don't know if it was for everybody, but
I said, I do many divorces. I've done it for 30 years. I generally do very good work. I ensure that my clients generally are satisfied with the quality of legal advice and representation. I like having happy clients. That's my personal thing. And when I bump into you at Yorkdale in 5 or 10 years from now, I want you to turn to whoever you're with at that point and say, that guy did my divorce properly, ethically, and responsibly. I do not want you to point to me while you're walking past me and say to your friend, you know what? I can't believe the deal I signed. I gave away the farm. I paid more than I should have. I didn't get what I'm entitled to. I didn't know what I didn't know at the moment. I want the conversation to be between you and your friend that, you know what? He made me do extra homework, but it was the right thing to do because what he did was he was the one guy that protected me when even I wasn't protecting me. And that's the conversation that I want. So pardon me, Mr. or Mrs. Client, I'm going to give you the homework to make sure that this divorce, which hopefully, by the way, will be your only divorce for the rest of your life, that this divorce was done once and it was done properly. Because I never want to hear that there was a problem with the nature, the process, or the outcome of your divorce. And one of those things that is needed, no different than a doctor needing blood tests and x-rays, we lawyers need the financial facts upon which we give you an opinion and upon which we begin the negotiation of a settlement. And yes, it's a pain in the ass, but it's a necessary pain in the ass to make sure that this is done right. If you want it to be done cheap, if you want it to be done fast, you've spoken to the wrong person. There are people out there that will do fast and cheap. I will not do fast and cheap because fast and cheap equals errors, negligence, mistakes, and quite frankly, financial damage, which I don't want you to experience.
Yeah, no, and I agree with that. And, you know, it's interesting. One of the things I see that comes up is, you know, often there's one party who's kind of pressuring the other party. And the person doing the pressuring is usually not the person who comes to see me because they're telling the other party. You know, I hate to generalize with genders, but it often, say the man was more sophisticated, involved in the finances, and he's telling the wife, let's not get lawyers involved. They're just going to run up the costs. We're going to end up spending a whole bunch of money on lawyers, and we don't need to. We don't need to do financial disclosure. And they pressure her. And they push her. And I always say to the woman in that situation, think about why he doesn't want you to have financial disclosure. Whose interest is that in? Is it in your interest or is it in his? And you know, it's in his. And so you have to look at the motivation of somebody who's telling you, you know, when your partner's telling you it's not necessary, you know, is it because that's going to benefit them?
So now let's educate the viewers. So we've talked about the situation primarily where people are splitting up and they've hired lawyers or not, but they're doing it out of court.
Right.
I'm going to
And we do have a couple questions that I think relate to.
Oh, do we?
Yeah, and I think it's going to relate to what you were just going to say, because I see a question here. Short of court, what are the options when the other side will not provide any financial disclosure? And then does an order need to be made if one party refuses to provide the financial disclosure?
All very good questions, and
Yeah.
I'm going to answer that in a second. But before we do answer those two questions, let's create the two scenarios, the out-of-court scenario and the in-court scenario. So to really appreciate the out-of-court scenario, everybody has to know what happens in court. So Leanne, when we issue an application for divorce, whereby we are asking for divorce, parenting, child support, spousal support, property division, as soon as we list any financial remedy, what is the applicant required to provide both to the other spouse and to the judge to even ask for financial relief?
Well, they're required to provide a financial statement, either something called a Form 13 or a Form 13.1, depending on whether they're asking for property division as well, or whether they're just asking for support, and whether, you know, it depends on other remedies as well, but that's the main difference.
And what does it include?
What's that?
And what's in it?
What's in what?
In the Form 13 or 13.1 financial statement.
Well, in the 13.1, you're going to have to provide the financial disclosure, which is going to include a listing of all of your assets, liabilities, your income, your expenses, and the documentation to back up all of those things. That's going to include, and plus your last 3 years, might be more, of income tax returns, notices of assessment. You'll be providing bank statements, credit card statements, mortgages, you know, letters of opinion or appraisals. There's a whole gamut of things that you will be providing. And if you're doing a Form 13, which is for support only, you don't have to provide any of the asset and liability information. It's focused on your income and your expenses. And in order to issue an application, you have to complete one of those two forms, and you have to provide all of that disclosure.
So let's pretend in our example, the husband hires you to prepare the divorce application. What forms are you preparing for him or with him to start the case in court?
Well, I'm going to be preparing the application, the Form 13.1, and then again, depending on whether if there's children and there's going to be custody issues, and the form number is like eluding me right now, but there's a form for that as well, and you're going to also
35.1.
35, yeah, that's right. And then there's an additional financial form, certificate of financial disclosure. I don't remember the number, but that's what the form is called, that you have to complete as well.
And that lists all of the disclosure that was provided to the other side, but you're not actually giving all of those documents to the court because they don't have much storage space left these days. But you're supposed to give it to the other side and just simply confirm to the court what you did give in this certificate of financial disclosure.
Exactly.
Okay, so you represent the husband, you issued it, I represent the wife, you serve my client, the wife. She walks in my door having gotten it yesterday. What do I have to do to satisfy her obligations under the family court rules?
Well, then she is going to have 30 days to serve and file her responding material, which will include an answer to the application. And she's going to have to provide her own financial disclosure, the same forms and disclosure that I mentioned that my client would have had to provide.
So it's perfectly reciprocal. Nobody is at an
exactly.
advantage over the other one, right?
Exactly. And she has 30 days to provide it. So when you're in a situation where one party is refusing to provide financial disclosure and you've been trying to move it forward, that is what you have to do sometimes is by filing, you know, the application with the court, now the other party is on a stricter time frame that they have to reply and respond with material. So it can be a way to force someone to provide financial disclosure when they're stalling and delaying.
So that answers Lisa and Sabina's question about short of court and what if an order is needed. And by the way, the subject of financial disclosure is one of, if not the number one source of annoyance of judges. They cannot stand it when people come to court and say, I'm not giving him or her such and such financial disclosure. It actually has gotten so severe. When I say it, I'm referring to the level of frustration of judges is so severe that judges have used vernacular to describe this. And one of the more recent, all the way up to the Supreme Court of Canada, they've called financial disclosure problems the cancer of family law. That's how severe it is. These are judges at the Supreme Court calling what Leanne and I are talking about the cancer of family law. Why is it cancerous? Because people feel very strongly about it, but it also is terribly infectious. It stands in the way of the health of the divorce. It spreads. It is something that we cannot get past. And so financial disclosure is a real issue. So going back to Lisa and Sabina's questions, oftentimes we actually have to issue the divorce application really just to cause financial disclosure. Everything else will fall into place. But if someone's not going to give us the value of their RSPs or what amount of money's in the bank account, and by the way, we talked about my tie today. I'm going to bring this back to my tie. Why am I wearing a tie today? Because I had 2 hearings today, one of which was I represented a woman who was seeking support from her ex-husband. And her ex-husband is a lawyer. And so not only is he an ex-husband in the case, he's also a lawyer in the case, although he's represented by another lawyer. And he swore a financial statement. And it was the financial statement that he swore that effectively is going to carry the day, because we really don't know what he's earning. But because he filled out the expense section where he lists what he spends every day, every week, every month, every year, that really was the basis of my arguments for what he earns, because he says he earns a low income, but at the same time, he also says he spends a significant annual budget. Well, my whole argument today was we don't really know what he's earning because he hasn't given us any of that financial disclosure. But I can tell you this, Judge, according to this, he spends $500,000 a year. Well, if you look at his last financial statement and look at this financial statement, his debt level has not risen. If anything, his net worth has risen, but he's spending $500,000 a year. Well, you don't have to be a rocket scientist, Judge, to know that if he's spending $500,000 a year and his debt level isn't going up and his assets are going up, he must be earning it. So please pay my client support on the basis of $500,000 a year, which, by the way, I grossed up to make it a much larger sum. But my point is, there are many reasons why people don't make financial disclosure, and there are many reasons why lawyers really push their clients, even against their own comfort zone, to initiate a court proceeding, a divorce application, really just to cause the financial disclosure to flow.
No, exactly. Sometimes it's the only way to get it, and to push it along. And the thing is, any person, who's served with an application, that person's been delaying providing financial disclosure, as soon as they go and speak to a lawyer is going to tell them, yes, you have to provide that disclosure. And there's no way around it. And if anything, I tell my clients, to err on the side of disclosing. If you have nothing to hide, then rather than fighting something, disclose it. Now, there are obviously certain situations where there are requests that are improper. They're requesting things that aren't relevant, or that there are, you know, privacy issues surrounding, or there's solicitor client privilege, or there could be, you know, all kinds of things that come up. So that's why, you know, it's very important to have a lawyer reviewing things, because a lawyer can tell you whether it is something that you must disclose, or whether you have a justifiable legal basis for not disclosing it. But that's not a determination that, you know, a non-lawyer really should be making.
So let me ask you something. Let's go the other way. What can you tell the viewers what is meant by the following two words? Fishing expedition.
Well,
Are we
I mean,
talking
it's
about
essentially
going to northern BC and going salmon fishing? Is that what they're talking about?
No, I mean, they're talking about exactly as it sounds. Sometimes a spouse will use the financial disclosure as a means to go on a fishing expedition to see if they can turn up, you know, extra information about the spouse that they want to know about. Like potentially, maybe they have a girlfriend or a boyfriend and they want to get information about the spending to see if they can substantiate that. Or sometimes I have a case right now where my client was charged with criminal harassment a number of years ago. Completely irrelevant to the situation at hand with his wife of many years, and she wants disclosure of all of the details of that. And it's, to me, that's just not relevant at all to the financial disclosure and what's going on with the party. So she's requesting it, I think, just to annoy him and trigger him and upset him and make him mad. And you know, so sometimes people go on a fishing expedition that way, but often it's just to try and turn up additional financial information that, you know, maybe shows their spouse had an affair or has a new partner or has, you know, things that aren't relevant to the proceedings. Like obviously, if you're concerned your spouse has more income than they're showing, that's not a fishing expedition. That's a valid, you know, a valid concern, although there has to still be some basis for it. But a fishing expedition is something that can be quite common. And again, that's why you need legal advice to shut it down.
So a few tidbits. Just like financial disclosure is on its surface a mandatory obligation for anybody going through divorce, there is discretion with respect to the level of disclosure. So you may not be able to prove everything. You may not be able to prove what you owned 20 years ago when you got married. Like you may not be able to find proof of a OSAP loan that you had when you got married. The general rule is if you can't prove it, you don't get the benefit. Okay, so if someone says, you know what, I had a $10,000 GIC when we got married, but I don't have any proof of it. Or I had $10,000 in cash in a pillowcase and we spent it on a trip. If you can't prove it and the other side doesn't agree, and they generally don't because it's to their disadvantage to them to agree, then it's unusable. Meaning the section in the Family Law Act specifically says the onus of proof of the person trying to claim a deduction is on the person claiming it. But what about the person that is in control of the asset that they are not disclosing? In those situations, then you do need to marshal evidence to indicate that it did exist. And there are many ways to do that. I'm not going to get into all the tricks and strategies involved, but suffice it to say, it is possible to hide assets, but it's also possible to uncover hidden assets. And there are many tools that we lawyers are aware of that we use to do so. But back to the subject of fishing expeditions and disclosure, just like financial disclosure is mandatory, abuse of financial disclosure can also be shut down by judges. And back to the questions that we had from some of the viewers, if somebody is abusing the request for financial disclosure, one of the benefits of being in court is to be able to shut it down and to get things to be resolved. And I want to be very clear with our viewers, just because you're in court does not mean you're in court for the whole 9 yards. In fact, a lot of people off-ramp from court shortly after they on-ramped it into court because they got what they wanted out of it. They got the disclosure, they got a judge's opinion that the disclosure needs to be made, or they got the judge's opinion about whatever the issue might be, and then they settled and they got out of court. So sometimes there's a rule or like a tool in the toolbox called court. You don't have to commit for the whole 9 yards.
And I think that, just if I could jump in there, I think that's a really important point, because what I see happens with a lot of people too is you get into these endless letter writing campaigns between counsel where, you know, months or a year can go on of letters back and forth, and clients have paid for all these letters, but they're no further ahead. And so, you know, sometimes just jumping into court at the beginning early on makes a lot more things happen, and then you can back away from it as appropriate.
Right. Whenever I go on the 401 going westbound, sometime when I just get out of the core, there's a building on the north side of the 401, somewhere around Keel, maybe Jane, and there's a big sign on it. It says Mantella. And the reason I mention this is because a number of years ago, one of the Mantellas was going through a divorce, and the wealthier one said to the one that married into the Mantella family, I'm not going to give you that disclosure. No way. Well, it ended up in front of Judge Corbett, and Judge Corbett ordered that the disclosure be made, but Judge Corbett went one step further and ordered that for every day that the disclosure is not made, that the person that should provide it, should be dinged a penalty. And I can't remember if it was $500 a day or $100 a day, something along those lines. Well, guess what happened? They did not make the disclosure. And it sort of added up to some huge amount of money. I can't remember exactly the sum. I'm not sure if it was like 100,000 or a couple of 100,000. But the bottom line is there was this amount triggered by the refusal to provide the financial disclosure. And then it came back to court, and guess what the question was? If it's a penalty, who gets it? Is it paid to the government of Ontario, or is it paid to the person that didn't get the disclosure? And I think it got resolved by being paid to in this case, the wife, I think. But my point of the matter is, this is how serious this subject is. This is not a light subject. So when clients say to us, I don't want to do this, why do I have to do it? Leave me alone. It's not about the lawyers. It's really about protecting the client and ensuring that this divorce that we do for them is done ethically, correctly, and responsibly, so that when we bump into them at Yorkdale, they say the right thing to their friend or colleague when it comes to the way we handle their divorce.
Exactly. Well said. And I think on that note, we can wrap it up. And thanks, Steve, for all of your great wisdom. And thanks to everyone who's joined in. And it was nice having some questions. So let's keep it, and feel free to DM either of us if you have questions or ideas for a future topic for our lives. We'd like to have them be as interactive as possible. So thanks for tuning in, and we will see you next week.
Take care.
Bye.
Bye, everyone.